very much. Now, the next order of business for all of you to stand and raise your right hand. I have to swear you in, okay? Okay. You will just simply answer after I'm completed with the sentence. Yes or no. The oath to each of you solemnly affirm under the penalty of perjury that the testimony you will give to this committee of the whole is the truth, the whole truth, and nothing but the truth. So help you God?
Yes.
Thank you very much. Please be seated. The chair recognizes Senator Kenneth L. Gittens for a point of inquiry.
Thank you, Mr. Chairman, and good afternoon to all. I heard the individuals identify themselves, and seeing that they are part of the first panel. My question is whether or not we'll have any representative of the Hovensa refinery here today.
Senator, the request was made for Lazard to appear, and we received a call on Friday noting that it was too short notice for them to come on Monday. Hovensa, I understand from today, my chief of staff contacted me while here in St. Croix and said that they received a call from Government House, Mr. Nathan Simmons, asking if the company, Hovensa, and Lazard can fly in to the territory to meet with senators. And we were unable to satisfy the request because of the late notice of the request and the fact that tomorrow is Veterans Day and senators have meetings already scheduled, some of them. So it was not convenient, but of course senators are interested in meeting with Lazard and Hovensa at some point. Thank you for your point of inquiry. I hope that satisfies your point.
So no representation from Hovensa, none from Lazard. So would any of these individuals on this panel be able to answer any questions pertaining to the current refinery management?
Oh, and I forgot to mention, thank you for the follow-up question. In fact, I forgot to mention, in the telephone call on Friday last week, the representative from Lazard, and I'm sorry I don't have the person's name, my chief of staff has that information, spoke to him, said that Mr. David, what's your different fellows? Dave Herr would be qualified to answer questions regarding the sales process. So that was the reason why I had invited Lazard, so that when we receive these issues, these questions about and concerns of companies who weren't able to bid for some reason. So I thought it'd be appropriate to have Lazard here to say, okay, why weren't they considered or not? But they said Dave Herr would be best suited to respond to such questions.
Thank you, Mr. Chair.
You're most welcome, Senator Gibbons. Who's in violation of the policy? Okay. She's excused. Record that into the record. Anyway, we'll proceed, and before doing this, everybody knew that today, this week is Founders Week for Omega Psi Phi Fraternity, one of the most distinguished African American fraternal organizations of which I belong to. The purple and gold bow tie represents that, and my purple and gold pen. So I'm a very happy guy today. Thank you, Mr. Alpha, Mr. Sigma. Thank you very much for your kind words. And Mr. Iota Phi Theta.
And me by me.
And all of me by me. And my Delta Sigma Theta sorority, Janet Milling Young. Thanks for your indulgence. Okay, at this time, on a serious note, we will move forward and begin with a testimony by the proponents of this agreement, and whichever you are designated to testify, you have to go first, please. Go ahead. Who's first? Attorney General Frazer? Okay, you may proceed. 1 second. You should have copies of all testimony. Is your testimony circulated or handed in to us? Yes. It is, right?
Yes.
Yes, I have a copy here. Sorry about that interruption. You may proceed, Attorney General Frazer.
Good afternoon, Mr. Chairman, the Honorable Sean Michael Malone, and the Honorable members of the 30th Legislature of the Virgin Islands. Good afternoon to the Senate staff and to the persons in the chambers and those in the listening and viewing audience. I am Vincent F. Frazer, Attorney General of the United States Virgin Islands. On behalf of Governor John P. DeYoung Jr. I want to thank you for the opportunity to appear this afternoon and to testify in support of the legislation ratifying a new operating agreement with the prospective buyers of Ovenza LLC, a comprehensive and detailed agreement which will govern the reconstruction, restart, and operation of the oil refinery located on the south shore of St. Croix, U.S. Virgin Islands. With me here today to provide answers and assistance in your reviewing this operating agreement are the Director of OMB, Ms. Deborah Gottlieb, the Director of the Office of Economic Research, Mr. Wharton Berger, the Acting Commissioner of DPNR, Mr. Jean-Pierre Oriol, Attorneys Peter Hebert and Jeffrey Eaton of the law firm of Winston & Strawn, and Mr. David Herr of the firm of Duff & Phelps LLC, the Governor's Refinery Advisors. The agreement we present to you today represents a culmination of more than 2.5 years of work on the part of the Governor and the government's negotiating team following the sudden announcement of Ovenza's officials of the closing of the refinery in January 2012 and the economic catastrophe that immediately followed. The administration's negotiating team consisted of most of the individuals appearing here today, except for Director Gottlieb, Director Berger, and Acting Commissioner Oriol. In addition, the team included Mr. David Paul of Fiscal Strategies, the Governor's Financial Advisors, and the Governor's Chief of Staff, Mr. Nathan Simmons. Former Commissioner Alicia Barnes was also on the negotiating team as well. Other government officials assisted as well as the need of or particular area of expertise required.
Excuse me, Attorney General. The Chair recognizes Senator Clifford Graham for a point of information.
Thank you, Mr. President. I'm sorry about that, but it appears that my copy only have the odd page numbers. I don't know, maybe.
Is it back and front? It's not. Okay, we have an error. Sorry about that.
Anyone else?
I think that's the case with most of us.
Use the finance chair.
Okay, I'm sorry, Attorney General Frazer. Those viewing or listening, those here with us, please accept this apologies for this slight inconvenience. That's okay. I think we copied you wrong.
Yeah, it should be back and forth.
No, when we made the copies, we didn't look at both sides.
We made back and front.
Some are, some aren't.
We
Okay.
made copies that should have back and front.
Yeah, you good. I think it happened in house here, so I will correct that. So those are my staff representatives listening. Colleagues, will you need a recess to get the actual copies or proceed for the testimony this time? Before you go, the Chair would like to recognize the presence of the Honorable Judy Buckley from the District of St. Croix. So, Madam Clerk, that brings our total to 13 present, 1 excused, and 1 absent. You're welcome, Senator Buckley, and welcome. Attorney General Frazer, you may proceed.
Thank you, Mr. Chairman. I was listening to members of the government team. I'll start here. The administration's negotiating team consisted of most of the individuals appearing here today, except for Director Gottlieb and Director Berger and Acting Commissioner Oriol. In addition, the team included Mr. David Paul of Fiscal Strategies, the Governor's Financial Advisors, Mr. Nathan Simmons, the Governor's Chief of Staff, and former Commissioner Alicia Barnes. Other government officials assisted as well as the need or particular area of expertise required. Likewise, the national and international resources of Winston & Strawn and Duff & Phelps were available to the team as well. The administration believes that this agreement with Atlantic Basin Refining Inc. and Atlantic Basin Refining Holdings LLC, hereinafter collectively referred to as ABR, offers an opportunity to restart sustainable refinery operations, jumpstart the territory's economy by bringing jobs of hundreds of high-paying jobs back to St. Croix, and provide substantial dedicated revenue streams to the government, including fixed payments that will total $1.6 million over the full life of the agreement. Just as important, the agreement provides for the first time that if the refinery cannot be returned to full operation or is returned...
Excuse me, Attorney General. Immediately want to send me a note about what's happening? It doesn't sound normal. Okay, proceed. Let me see if you begin to, again, when you speak, then I'll know and then I get. Proceed.
Just as important, the agreement provides for the first time that if the refinery cannot be returned to full operations or is returned to full operations only to be closed again, the new owners will pay for the refinery to be deconstructed and the refinery site cleaned up. But as you consider this agreement, and as the public focuses its attention on the matter, it is absolutely essential that this be considered in full bright light of reality. And the reality is this. Hovensa shut down on effectively no notice, declaring that the refinery had lost over $1 billion prior to its closure. With the shutdown, we were threatened with a cutoff of motor fuel for the territory and the exclusive source on St. Croix. WAPA lost its beneficial fuel prices, thereby driving its costs up, just as we were poised to begin to recover from the effects of the Great Recession, thereby costing every resident and business in the territory. When this happened, the administration fought Hovensa every step of the way until we got assurances about fuel supply, a transition on WAPA pricing, and most importantly, the Fourth Amendment, which required Hovensa to look for a buyer who was willing to buy and restart the refinery. If we do not move forward, we are back to where we began, with a company unwilling to operate a business that provides St. Croix with fuel, unwilling to maintain a facility that could be restarted by others, and unwilling to pay the government anything for what they have done because of the decades-old series of concession agreements and amendments approved by your predecessor and the administration, never addressed what would happen if the company just walked away. The administration included in the fiscal year 2015 budget submission the $40 million of the NRD settlement, which is to be paid at the closing of the ABR purchase. If that closing does not take place, do we really believe that Hovensa will voluntarily pay over $40 million without demanding once again from the territory that we simply take what they offer and release them from what we firmly believe are breaches of their obligations? We do have a lien on the equipment and fixture, but it will take months and possibly more battles to turn that lien into cash. Thus, as we proceed, I ask us all, those here, those listening, and those commenting, to keep in mind that there is a reality here that cannot be ignored. Furthermore, before I review both the background of events that brought us to this day, as well as the provisions of the agreement that is before you for review and ratification, which action is a requirement if we are to put people back to work on St. Croix and generate economic activity that will pull the island of St. Croix and indeed the territory out of the economic and fiscal crisis that has held us in its devastating grip. I would like to inform you that a similar process of final review for approval is proceeding at the corporate level by owners of Hovensa, the Hess Corporation, and PDVSA, the National Oil Company of Venezuela. We and they are working as expeditiously as possible on parallel tracks so that we can all arrive at the path, we can all arrive at the same destination as quickly as possible. For us, the essential next step that we as a territory can take on the path towards the closing of the sale of the refinery by Hovensa to ABR is for this legislature to ratify the agreement with ABR. Only then will ABR be in a position to move to the closing of the transaction it has negotiated with Hovensa. And only with that sale can the new owners begin the complicated and technical phases of engineering, design, and financing necessary to safely restart a refinery that can thrive in an evolving national and global oil and gas industry. I trust that when I have completed this presentation and the administration's negotiating team has addressed your questions, we will all be a lot closer to that day. For that day will be a milestone on the road to our achieving our ultimate goal of putting hundreds of residents on St. Croix back to work and starting the flow of hundreds of millions of dollars into and through the broader economy of St. Croix and the Virgin Islands. Now as the background. In considering this agreement, I believe it is important to briefly recall the series of events that brought us to this point. As you are aware, the government is a party to a concession agreement binding the government, Hovensa, and Hovensa's owners, Hess Oil Virgin Islands Corp., known as HOVIC, and PDVSA VI, to a series of mutual obligations. In exchange for the right to conduct a refinery business on St. Croix, an exemption from certain taxes, duties, and other fees, Hovensa and its predecessor companies agreed to construct, operate, and maintain the oil refinery at Lime Tree Bay, and to provide the government with economic benefits in the form of annual fixed payments, fuel oil subsidies, corporate taxes, and other benefits. As amended and extended from time to time, the concession agreement has governed the operations of the refinery for nearly 50 years. On January 18, 2012, with less than 24 hours notice to the government, and with 10 full years left in the concession agreement's terms, Hovensa announced its intention to cease refining operations. Operations ceased just a few weeks later. The economic devastation wrought by the closure can hardly be overstated. As the members of this legislature are personally aware, and as our community has so painfully experienced, the plant's sudden closure deprived the territory of more than 2,000 jobs, more than $100 million annually in lost direct and indirect revenues, and more than $500 million annually in total economic activity. Laid off workers who had opportunities elsewhere left the island in mass. Those that remained sought work in an economy in which there was little to be found. Unemployment soared. Their customers gone, retail stores and other businesses were forced to shut down. Schools were closed. Not content with wrecking our economy on 24 hours notice, Hovensa and its owners also informed the government that they would no longer honor certain of the contractual obligations under the concession agreement, most notably the obligation to provide subsidized fuel oil to WAPA. They further demanded amendments to the concession agreement that would both grant them additional tax benefits and dramatically reduce their financial obligations to the government. This demand was accompanied by public intimations from Hovensa's CEO that if the government did not agree, Hovensa and its owners would cut off St. Croix's access to gasoline and diesel fuel. Despite facing this extraordinary pressure, the governor declined to be strong-armed into submission or into a bad deal. Recognizing the long-term importance of the refinery to the territory's economic health, the governor, with the legislature's approval, instead retained an experienced oil and gas industry financial advisory firm, Duff & Phelps. The Duff & Phelps team, led by David Herr, performed a comprehensive analysis of the refinery and its shutdown, including an evaluation of the economic prospects for reconfiguration and restart of the refinery, as well as a wide range of alternative uses for the refinery site. Duff and Phelps' conclusion was clear. The highest and best use for the Hovensa facility was and remains an oil refinery. Their analysis pointed out that despite Hovensa's inability to operate the refinery profitably, there were reasons to believe that in the hands of another operator, one willing and able to invest and reconfigure the refinery for a different kind of refinery operation and a different mix of crude oil, might be able to run the refinery successfully. It explained that the refining industry is cyclical, and that the years leading up to the refinery's closure likely represented a low point of the profitability cycle. It further pointed out that a new operator, one not constrained by Hovensa's long-term supply contract for heavy Venezuelan crude oil, could take advantage of the discovery and exploitation of vast new reserves of light sweet crude oil in the mainland United States to more efficiently run the refinery with lower costs and a cleaner environmental footprint, while taking advantage of the territory's Jones Act exemption to achieve substantial cost advantages relative to other U.S. refineries. In using crude oil from shale sources like the Eagle Ford or the Permian Basin, an operator can also use natural gas liquids found within the crude oil extraction, like ethane, propane, and other similar fuels, which could then be used to fuel the refinery's power generation units, again resulting in significant cost savings and a cleaner environmental footprint. Armed with the Duff and Phelps report, the governor concluded that the territory's long-term interests required that the refinery be sold to a new owner, one willing to reconfigure the facility and restart refinery operations. The governor announced that conclusion in a private address in August of 2012, stating the government's position that if Hovensa and its owners were not willing to resume operations on their own, they should work with the government to identify new owners who will work with us to achieve the result we seek, and operating an efficient oil refinery on St. Croix, providing jobs and revenues for the territory. Hovensa and its owners initially refused to discuss the possibility of a sale. Only after nearly 6 months of contentious negotiations did they agree to attempt to sell the refinery to a willing operator. The Fourth Amendment Agreement, executed by the owners and the governor on April 3, 2013, required Hovensa's owners to take a bona fide process to sell the refinery. In exchange, Hovensa received a temporary reduction in its annual fixed payments from $14 million to $7 million, and was permitted to operate the facility as a storage terminal through 2019 if the refinery did not sell. The agreement was ratified by the 30th Legislature on November 5, 2013, and approved by the governor on November 7, 2013, and it's enacted in Act number 7566. The sales process formally launched in January of 2014. The owners, investment bankers at Lazard Brothers contacted nearly 125 potential purchasers, including national oil companies, major private oil companies, refining companies, and private equity firms. Lazard applied a consistent standard for proof of financial and operating expertise in their screening process, and required buyers to demonstrate both to be allowed access to the confidential information. Lazard received approximately a dozen expressions of interest and 4 companies indicated serious interest in purchasing the facility after obtaining access to confidential information in a data room. Of those, half dropped out before completing on-site due diligence, and the remaining 2 were provided with the government's preliminary term sheet for a new operating agreement to replace the concession agreement. 1 ultimately declined to submit a bid after returning an initial response to the government's term sheet that was entirely unacceptable. The only company to actually submit a bid was Atlantic Basin Refinery, Inc., ABR, a company formed specifically to acquire and operate this refinery. ABR is led by a group of 5 individuals with expertise and experience in the oil and gas industry, energy trading, and brownfield restoration. ABR principals are here today, and I will leave it to them to introduce themselves and their vision for the refinery. In August of 2014, the owners reached an agreement in principle with ABR on the terms of a purchase and sale agreement, subject to ABR fulfilling numerous closing obligations. Shortly thereafter, the owners' investment bankers at Lazard arranged an introductory meeting between the government and ABR's principals. At that meeting, ABR explained its plans for reconfiguring and restarting the refinery. The government also met with ABR's engineering consultants and financial advisors to assess and confirm the viability of ABR's plan and the advisors' commitment to ABR and the restart. With knowledge of the risks and opportunities associated with ABR's plans, the government and ABR entered into direct negotiations over the terms of a new operating agreement. Those negotiations were lengthy and sometimes contentious, as the government sought substantial protections within the operating agreement to protect the territory's interests at all stages throughout ABR's restart plan. Ultimately, however, the parties were able to bridge their differences and reach agreement on the terms of the new operating agreement, under which ABR would reconstruct, restart, and operate the refinery if that course of action proves to be financeable, and the terms on which ABR would deconstruct the refinery and clean up the site if it does not. The government and ABR executed the new operating agreement on October 29, 2014. An exhibit to that operating agreement is a termination and release agreement, which by its terms releases all parties to the old concession agreement from all their rights and obligations arising under that agreement. Execution of that termination and release agreement by all parties to the concession agreement is a condition to the closing of any sale. I will now briefly describe the structure and content of the operating agreement. The basic structure of the operating agreement is driven by the mandate issued by the government nearly 2 years ago. The territory wants an operating refinery, or if that is not to be, it wants the site cleaned up. He wants the site cleaned up. The agreement is designed to create every possible incentive for the new owners to reopen and restart the refinery, and if they fail, to require them to deconstruct the facility and remediate the site. Within that basic structure, the agreement is designed to impose certain operational requirements on ABR to maximize payments to the government under both a scenario where the refinery opens and a scenario where it does not, and to provide the government with a comprehensive set of powerful remedies in the event that ABR, for some reason, fails to perform. The operational requirements. The agreement's terms are structured in part around the recognition that the single most important factor in achieving a reopened refinery is ABR's ability to obtain and repay the roughly $1 billion, billion with a B, in debt financing that will be necessary to fund the reconstruction, reconfiguration, and rehabilitation of the facility. To that end, the agreement is framed around a series of operational requirements corresponding to key steps in obtaining financing and restarting operations. Those operational requirements include an engineering phase, which will determine the feasibility of the planned reconfiguration and restart, and provide a detailed plan and cost estimate for achieving it. A financing phase in which ABR will secure and invest the funds as much as $1 billion or more needed to implement the restart plan. And a restart operational phase in which ABR will restart the refinery, repay the outstanding debt, financing, and return to regular refinery operations at the minimum baseline level. The engineering phase, 10 to 12 months after closing. After closing, ABR must immediately retain a reputable engineering firm to prepare a plan for reconfiguring and restarting the refinery, together with a cost estimate for implementing that plan. ABR and its engineers then have 10 months to provide that plan and estimate to the government, together with a signed contract with the engineering firm to implement the plan. ABR will be permitted to operate the facility as a storage terminal during this phase to fund its payment obligations to the government. It is our understanding that ABR has already selected an engineering firm, and that firm is ready to commence its work at the refinery. Financing phase, 15 to 20 months after closing. After obtaining the required engineering plan, ABR has a short window in which to demonstrate to the government binding commitments for the financing necessary to implement the plan. If ABR fails to meet this requirement, such that no financing is obtained and no restart of the refinery is possible, it will be in breach of the agreement, with significant financial and cleanup related consequences. ABR will be permitted to operate the facility as a storage terminal during this phase to fund its continued obligations to the government. The restart and operational phase, up to 48 to 60 months after closing. Assuming that ABR is able timely to obtain necessary financing, it has a period of approximately 2 years to implement the engineering plan, reconstruct and reconfigure the refinery, and restart refining operations. The agreement requires that the refinery be restored to operational capacity of 350,000 barrels per day, and further requires that not less than 20 months after restart, it must be operating consistently at an operational baseline of 300,000 barrels per day. ABR must certify the refinery's refining output to the government every month, and if the certifications demonstrate that ABR is not achieving the operational baseline for an extended period, called an extended refinery idling event in the agreement, it will be in breach of the agreement with significant financial and cleanup related consequences. Beginning on the restart date, ABR will be required to employ not fewer than 600 full-time equivalent workers, of whom 500 must be employees rather than contractors. Of those 500 full-time employees, 75% must be residents of the Virgin Islands. Satisfaction of this employment requirement will entitle ABR to a reduction in certain of its payments to the government, as I will explain momentarily. ABR's payment to the government. The agreement provides for a comprehensive package of payments to the government, which are intended to provide a dedicated, predictable income stream to the government, regardless of the refinery's performance. Permit the government to also capture significant upside revenues if the refinery operates profitably, and fund the future deconstruction and cleanup of the refinery site. Signing and closing payments. In recognition of the risk the government is assuming in entering into a long-term agreement with a new and thinly capitalized company, upon signing of the operating agreement, ABR will place in escrow the sum of $1 million, which will be paid over to the government if, as a result of ABR's failure to meet certain of its closing conditions, this transaction does not close. Upon closing of the deal, the government will receive $5 million to cover its costs and expenses associated with the transaction. Also, I close, the government will receive $40 million in satisfaction of Provenza's obligation under the settlement agreement of the NRD litigation. In addition, ABR will open a trust account to hold funds for the future deconstruction and remediation of the refinery site, and will place $500,000 in that account. This trust account will have a trustee agreement which gives the government interest in the disbursement of the funds. Earn out payments. The government will also receive 20% of the gross proceeds of the sale of Provenza to ABR. Under the terms of its purchase and sale agreement with the current owners of Provenza, ABR will pay the owners $200 million within a 6-year period, within over a 6-year period, plus 50% of the proceeds of any sale of the coker and the catalytic cracking unit. Accordingly, the government will receive from ABR an additional $40 to $50 million over this period of time. Operating payments. The agreement's payment structure is designed to give ABR maximum flexibility, maximum financial flexibility in the early years of the project, so that it can demonstrate the ability to repay the financing needed to fund the reconfiguration. When it is seeking the financing, investing it in the refinery and repaying. Once the critical financing period is over, or if for some reason ABR is never able to obtain the financing, the required payments will go up substantially. The operating agreement provides for 3 primary kinds of payments. Fixed payments, which are essentially payments in lieu of property tax and other fees. Variable payments, which are essentially payments in lieu of corporate income taxes. And site restoration payments, which are funds paid to a third-party trust account and specifically for the future deconstruction and cleanup of the facility. I will discuss the site restoration payment in more detail. The numbers break down as follows. For all years in which ABR is not in breach of its material obligation under the agreement, in years 1 to 6, they will make fixed payments equal to $14 million. 0 variable payments, 0 site restoration payments. That is, in the first 6 years of the agreement, ABR will pay the same fixed payment that Provenza owed under the old concession agreement. It will not owe any variable payments, and it will not be obligated for any site restoration payments. The financial burden on ABR in those years is limited in order to maximize ABR's ability to obtain, invest, and repay as much as $1 billion in debt financing. That $1 billion investment in the facility is critical to restoring economic activity to St. Croix for decades to come, and will pave the way for more lucrative operations once the reconfiguration is complete. In year 7, ABR will make a fixed payment of $32 million. Variable payments will be provided on income from 0 to $100 million. They will pay 0%. From $200 million to $500 million, they will pay the government 10%. For anything over $500 million, they will pay 12.5%. In each case, these payments may be reduced by 5% if ABR meets the required employment threshold. In year 7, there will be no site restoration payments. In year 8 to 10, ABR will make a fixed payment of $32 million. Variable payments will be 7.5% of up to $100 million, 10% from $100 million to $500 million, 12.5% of any income over $500 million. And again, they will receive a reduction of 5% if they maintain the required employment threshold. And there will be no restoration payment. In year 11 to 15, ABR will make a fixed payment of $36 million per year. Variable payments will be 10% of up to $100 million of their net income, 13% on their income from $100 million to $250 million, 20% from $250 million to $500 million, 25% in any income in excess of $500 million. Then it will begin to make a site restoration payment of $5 million. In years 16 to 22, there will be a fixed payment of $40 million per year. Variable payments will be 10%, up to $10 million, 13% on income between $100 million to $250 million, 20% on net income from $250 million to $500 million, 25% on net income in excess of $500 million, and an annual site restoration payment of $5 million. In the first extension period, in years 22 to years 32, ABR will make a fixed payment of $45 million in year 22 and adjusted thereafter for inflation. Variable payments will be 10%, 13%, 10%, 13%, 20%, and 25%, as they were before. And again, a $5 million restoration payment fund per year. In the second extension period, which covers year 32 to 42, they will make a fixed payment at either a choice, given ABR choice, a fixed payment amount from year 32, which is $45 million thereafter with inflation, or we'll have an opportunity for a renegotiated amount to be determined by arbitration if agreement cannot be reached. Variable payments will continue at 10% of up to $100 million, 13% on income between $100 million to $250 million, 20% on net income from $250 million to $500 million, 25% in income in excess of $500 million. For all years in which ABR is going now, where they are in breach of any material obligation, for example, a failure to obtain financing, or they fail to operate a refinery at baseline level, or cease refining operations. In those instances, if ABR fails to obtain financing at all, in the first 3 years after ABR fails to obtain financing, the fixed payment is $15 million per year for each year thereafter. Each year after, it jumps to $30 million. If ABR obtains financing but is unable to restart the refinery, or it restarts and subsequently shuts it down for the period in which the refinancing is still being repaid, it will pay $15 million per year. For each year thereafter, they will pay $22 million. That's each year after the financing is repaid. Then they'll pay $22 million per year. The variable payments in the event of a breach are as follows. 5% of taxable income up to $50 million, 15% of taxable income from $50 to $100 million, 20% taxable income from $100 million to $500 million, and 25% of taxable income in excess of $500 million. In addition, ABR's obligation to fund the site restoration account will also increase to the greater of $10 million, or 17.5% of the modified EBITDA per year, if financing is never obtained, or the greater of 7.5 million, or 17.5% of modified EBITDA per year, if the breach occurs after financing is obtained. That is, if ABR fails to obtain the financing necessary to restart the refinery and instead is operating it as a storage terminal, its annual payments to the government will be at least $30 million annually, plus variable payments on any taxable income, plus a minimum of $10 million to fund the future deconstruction and cleanup of the site. ABR's payments following a breach are substantial, but that is the point. They will be secured by a third-party guarantee on a revolving restarting. ABR's payments following a breach are substantial, and that is the point. They will be secured, their payments will be secured by a third-party guarantee on a revolving basis, as discussed below. And by keeping those payments high and ABR profit margins correspondingly low, the agreement provides ABR with a strong incentive to make the necessary investment to restart the refinery and keep the refinery operating. The site restoration and the site restoration payments. A key feature of this agreement, and one that to my knowledge makes it entirely unique, is ABR's commitment to fund the eventual deconstruction and cleanup of the refinery and the refinery site. From the earliest negotiations with ABR, the government made it clear that a fundamental condition of any agreement must be that if and when the refinery can no longer be operated profitably, its physical assets must be removed from the site and the site itself cleaned up. Under no circumstances may the territory be left with a rusting industrial facility on the south shore of St. Croix, marring the landscape and preventing the restoration of the site. Accordingly, under the agreement, at closing, ABR must open an interest-bearing trust account with a reputable third-party trustee acceptable to the government for the sole purpose of holding the funds necessary to effect the deconstruction and cleanup of the refinery site. ABR will initially fund that account with $500,000. For the 10-year period in which ABR is obtaining financing, investing, and repaying its financing and is not in breach, it will not be required to make contributions to the account. but beginning in year 11, it must deposit $5 million in the account annually for the duration of the agreement's term. More importantly, if ABR fails to obtain financing, or if it obtains financing but is unable to restart or to sustain refinery operations, it will immediately become obligated to deposit into the trust account annually the greater of $10 million, or 17.5% of modified EBITDA. This means, for example, that if ABR fails to obtain financing by the third year after closing, by the 15th year after closing, the account will hold at least $120 million, which may be used for no purpose other than the deconstruction of the refinery and the cleanup of the site. By the 20th year, that sum would rise to $170 million plus accumulated interest. Of course, if ABR does obtain financing and successfully operates the refinery at the required level, the funds in the account will grow much more slowly. We believe this is acceptable, however, because so long as the refinery is operational, it would make no sense to rush its deconstruction. Only when the refinery no longer offers the prospect of extensive employment and substantial economic activity does it become imperative to plan for and fund its removal. Make no mistake, under this agreement, the refinery and its related facilities will ultimately be taken down and the site cleaned up. By the time the agreement has run its course, there will be no industrial eyesore marring the views of the South Shore. The government's contractual protections and remedies. As you are all aware, the old concession agreement failed to provide the government with specified and meaningful remedies in the event that, for example, the owners breached their obligation to operate the refinery. The government was all but left at the mercy of the owners, who could and did violate their duties under the agreement with impunity, knowing that the government had no meaningful protection except for costly and disruptive litigation. The new operating agreement was drafted with the express intent to avoid that problem and also to provide additional remedies appropriate for a contractual relationship with a new owner who, however sophisticated and well-intended, may be thinly capitalized and lack the traditional financial resources of a more established company. To mitigate the risks associated with doing business with ABR and with the complexities of the business deal, the agreement protects the government in three specific ways. First, it provides expressly that certain significant operational failures by ABR constitute breaches of the agreement and trigger predetermined consequences, including increases in ABR's payment obligations to the government and the affirmative obligation to fund and conduct the deconstruction and cleanup of the site. Second, it requires a third-party guarantee of ABR's financial obligations during critical periods of the contract, including the period from closing to restarting, and importantly, the period following any breach of the agreement. And third, it guarantees to the government an expansive security interest in the oil refinery and related facilities, which provides the government with a remedy of last resort in the event that ABR fails to meet its financial obligations. Operational breaches and remedies. The agreement provides that certain performance failures by ABR will constitute a breach of the agreement and will trigger predetermined consequences that protect the government's interests. Defined breaches include the failure to timely obtain the required engineering study and reconfiguration plan, the failure to timely obtain financing to fund that plan, and the failure to timely restart and operate the refinery at the agreed baseline level of 300,000 barrels per day. If ABR commits any of these breaches and fails to cure, the following consequences will result. ABR must immediately commission a study to determine the cost of deconstructing and cleaning up first the refinery and later the terminal. ABR must immediately begin funding the site restoration account in the amount of the greater of $10 million or 17.5% of the modified EBITDA annually. Upon a determination that the site restoration fund account holds sufficient funds to fund the deconstruction and cleanup of the refinery, ABR must commence deconstructing and cleaning up of the refinery. Upon its determination that the site restoration fund account holds sufficient funds to fund the deconstruction, upon the determination that the site restoration fund account holds sufficient funds to fund the deconstruction and cleanup of the terminal, ABR must commence deconstructing and cleaning up the terminal, except for those parts necessary to operate the fuel loading rack and maintain storage sufficient to meet the needs of Synchrone. Financial assurance. The agreement also requires ABR to maintain in place two kinds of financial assurance to guarantee its payment obligations under this agreement. First of all, ABR's obligations are specifically guaranteed by both the operating company's parent companies, ABR Holdings and ABR Inc. This ensures that to the extent that the parent companies have resources that the operating company does not, for example, if refinery profits are passed through the parents in the form of dividends, they can be made liable for the financial shortfalls of the operating company. More importantly, for certain critical important periods, ABR is required to maintain in place a third-party guarantee acceptable to the government of its financial obligations, likely in the form of a letter of credit from a reputable financial institution. That third-party guarantee must be in place for 3 distinct periods. 1, the engineering financing phase period assurance. ABR must have a guarantee in place for all fixed payments for the period from closing through the date on which ABR is required to demonstrate committed financing. 2, during the restart phase assurance. ABR must have a guarantee in place for all fixed payments for the period from the closing date of any financing through the date on which the refinery restarts operation. 3, a default assurance. In addition, in the event that ABR either commits an operational breach or fails to timely make a payment, ABR must have in place third-party financial assurance sufficient to guarantee the next 12 months of fixed payments and site restoration payments on a revolving basis. The existence of this third-party guarantee substantially mitigates the risk that ABR will fail to make its payments to the government. Failure to maintain the required third-party assurance is a breach and will trigger ABR's duty to fund and implement the deconstruction and cleanup of the facility. Subordinated security interests. Finally, the agreement requires ABR to grant to the government a mortgage and security interest in the refinery and the related facilities, including not only the real property, but also the fixtures, equipment, and personal property required to operate the refinery. In the event that ABR fails to make required payments under the agreement, and for some reason those payments cannot be satisfied by the financial assurance, the government can foreclose on its security interest and take possession of the facility. In order to accommodate ABR's need to obtain significant debt financing to restart the refinery, the government's security interest will be subordinated to any such financing. What this means, as a practical matter, is that if ABR finds itself in financial difficulty, the government would be unable to enforce its security interests so long as the financing is in place. This subordination is necessary to enable them to get the financing, but it does not materially harm the government's position. If ABR were unable to pay its lenders, those lenders will be able to enforce their senior security interests ahead of the government. But because the lenders only means for recovering the investment in the refinery would be to step into the shoes of ABR under the operating agreement, they would have every incentive to make all the payments owed by ABR under that agreement. In all likelihood, the government would continue to be paid just by ABR lenders rather than by ABR itself. Between the structure of the agreement itself, the requirement of third-party financial assurance, and the security interest, the agreement provides the government with an extraordinary amount of protection against the risk associated with ABR's business plan. Although no contract can entirely eliminate the risk of failure, we believe that the agreement as signed offers protection for the government's interest that more than makes up for the possibility that ABR may ultimately fail in what it has agreed to do. Moreover, when you consider the threatened refinery closure and restart in the mid-Atlantic states of Pennsylvania and Delaware, this operating agreement is vastly superior. In Pennsylvania, an aggregate of state and local incentive package reported to be between $25 to $30 million to Sunoco refinery restart to keep it open. The government didn't participate in the sales proceeds of the sale of that refinery. And the minimum job guarantee is 400 jobs. In Delaware, to facilitate the restart of the refinery, the state provided a $30 million interest-free financing deal, which may convert to a grant if the operator maintains a 5-year employment target. The minimum job requirement was also 400 jobs, which has been expanded. Further, the company was provided, the cost was provided in connection, I'm sorry, I have a split in my reading here. All right, the company was provided with a 5-year tax holiday on property tax. The point I wanted to make by that sentence.
Where is it?
That's in the Delaware refinery. The government's negotiating team believes that this operating agreement is comparable to similar public-private transactions of this nature. In this agreement, the government receives an immediate infusion of cash, which is in need of new money, of cash to this government, which is in need of new money in order to close the budget gap in the fiscal 2015 budget. We have provided a certain means to ensure the dismantling of the oil refineries if it will not be operational, which is a benefit that does not now exist in the current and past agreements. We have built in escalation provisions for the increases in the fixed payment pilot obligations. There are clear consequences for default, which were not in the previous agreements, and we have provided a means to ensure that the government will receive variable tax payment if the operator is making profits. This agreement addresses all of the possible contingencies that the team could conceive. Senators, the rejection of this agreement eliminates access to jobs for Crucians in the near term. The additional business activity that St. Croix and our territory can benefit from, and will ensure that St. Croix will continue in a state of economic demise and negative economic stagnation. The territory cannot afford further postponement of the restart of a refinery that can serve as the ignition of its economic engine. It is our understanding that contractors and financiers are standing ready to make the investment, provide the expertise, and the new job opportunities for the residents of our territory. This agreement represents a new paradigm upon which this legislature can restart the rebuilding of the St. Croix economy and the economy of the territory. Likewise, by this agreement, the territory can resume its place in the refining industry and provide the resultant benefits that flow to the residents of the United States Virgin Islands. Mr. President, on behalf of Governor John P. DeYoung and the rest of the negotiating team, I thank you for this opportunity to present to you the proposed operating agreement. The document we present to you today is the product of both careful consideration and difficult negotiations. And although no agreement is perfect, I believe that what we have presented here today represents a good and fair deal for the government and for the people of the Virgin Islands, and one that offers the best available chance for a renewed economy on St. Croix and a more prosperous future for the territory of its people. I thank you, and I and the rest of the team will stand ready to answer any questions that you might have. Thank you.
You're welcome. And thank you, Attorney General Frazer, for your testimony. There'll be other testifiers, correct? Like from the company, Atlantic Basin Refining Holdings, will be testifying, correct? Okay, good.
Point of inquiry before you call the other testifier, please.
The chair recognizes Senator Kenneth Gittens for a point of inquiry.
Point of inquiry and a point of clarification. On page 9, the Attorney General, I believe he added right after the first sentence, where it reads the territory wants an operating refinery, or if that is not to be, it wants the site clean up, and then he added he wants the site cleaned up, and I'm quoting what he said. I need to know who is he as we go forward. And on page 9 and on page 13, it might have been a error on his part, but he referred to in the third, I'll say in the third paragraph there, I'll just count those other two as paragraphs, where it says, also at close, the government will receive 40 million in satisfaction of Hovic's obligation. However, you stated Hovensa. Which one is it?
Hovensa's obligation.
Hovensa's obligation.
Hovensa and Hovic.
That's to the chair, by the way.
I'm sorry, Mr. Chair.
He's not recognized for questions yet. This is a point of inquiry. So all questions will be directed to the chair. Thank you.
And
We'll
just,
see to something
for clarification, can he let us know those two?
Yes, Attorney General Frazer.
Yes. As for page 13, the obligation, the direct action was against Hovensa. Hovic, as its parent company, was named as a party, but its obligation was expected to be paid by Hovensa, LLC. So I made a correction when I read my statement as Hovensa.
Senator Gittens.
So it is Hovensa and not Hovensa and Hovic, as he previously stated just now.
Attorney General.
Hovensa.
Thank you.
Okay. Satisfy your point of inquiry and clarification.
Well, page 9. You still,
Okay, page 9, Senator Attorney General Frazer.
Yes, through the chair, the reference to he that I read was the governor.
Thank you.
Governor.
Okay, you're welcome. Now, before I recognize the next testifier, Attorney General, throughout the operating agreement, it references purchase agreement, somewhere between, of course, the ABR and Hovensa. Will the legislature be privy to a copy of this document as well as the settlement agreement with NDR?
We do not have a copy of the purchase agreement, the sale and purchase agreement. We were not provided a copy. We were given an opportunity to review it so that we can consider the government's interest in aligning with the agreement, but the company refused to give the government a copy for distribution.
Okay, what about the settlement agreement?
The settlement agreement can be provided, Mr. Chairman.
Okay, to get a copy of that. And the reason for these questions, Attorney General, the all legal counsel needs these documents to make a proper analysis. Okay? So, certainly, Senator Nelson, one moment. So, I understand your explanation on the record about the purchase agreement, but it's necessary for the council and this legislature to do a complete and thorough analysis. Okay? The chair recognizes Senator Nelson. What's your point of clarification?
I heard the Attorney General respond to your inquiry, Mr. President, that the government did not get a copy of the purchase agreement. The term agreement means something signed by both parties, the government and whomever. We should be entitled to a copy. So the government must have a copy. If it's different, if he has one and does not want to present it here, but he can't say the government as a party to an agreement does not have a copy and was not furnished a copy. That does not even make good sense.
Thank you, Senator Nelson. That was a point of something.
May I clarify?
Attorney General?
May I clarify? The government is not a party to the purchase and sale agreement. The purchase and sale agreement is between Hovic and ABR. It is treated as a confidential sales document between those parties. The government is not a party to it. I'm sorry, and PDVSA VI, I'm sorry. Hovic and PDVSA VI and ABR. We insisted on reviewing it. It was we were initially refused. We insisted we're not going forward with the operating agreement negotiations unless we can see it and review it, and then we were given that opportunity. It was not signed. There is a agreement in principle that the parties will execute after the approval of an agreement, operating agreement.
Thank you, Attorney General Frazer. The chair recognizes Senator Nelson for a point of information.
Mr. Chair, that's why it's so important that we have some kind of memory of what transpired. The fourth extension agreement supposedly tied the government to the sales process. So how are you telling me now the government is not a part of the sales process, even though I know that was jive then, but now you're admitting it.
The government is not a party
To the chair.
to the agreement, through the chair. The government is not a signatory as a party to the purchase and sale agreement.
Not responding to the fourth extension.
Mr. Chair, he's not responding to the fourth, what I claim that the fourth extension agreement tied the government to the sales process. I can accept his other explanation.
Thank you, Senator Nelson. Thank you, Attorney General Frazer.
We were tied to the sale process. We had a role in the review of the sales process, but it does not give us the access or put us as a signatory on the purchase and sale document.
Thank you for your response. Now I'd like the chair now recognizes the principals of Atlantic Basin Refining Holdings and Atlantic Basin Refining LLC. I think they're two different entities. Okay, so